Hello, everyone. I hope you're sufficiently caffeinated for this anthropology lesson on succession plans. I've got a bit of I'm not going to be able to see my slides there, so I'm just going to try to do a dual role. If my slides don't change there and I'm rookie about it, please let me know and I'll just quickly point to change it. So the topic for today is, all right, settle down. I'm speaking already. So the topic for today's presentation for me is succession planning for listed companies in India as a case study. As a novice governance researcher, because you see, I don't believe that I've been a very versatile academic till recently, that is this paper. Came to mind because you see it is a consideration ex ante from a governance perspective and ex post from an enforcement perspective, and there seems to be a bit of a counterbalance when you look at the manner in which the market in India has moved, which is something that we already touched upon in the previous panel. So what I've done is I've divided this particular paper along with my young co-author who's sitting over there, Dharmil, and my more senior co-author, I'm like in that sandwich era of academia right now, who's sitting all the way in India, who's lived through some of these succession disputes as well, is to look at what governance with respect to succession is from a regulatory standpoint, and then whether such planning actually works. So the question of, is this governance protocol regulation actually mattering? Which is essentially how this paper has been divided into two. I must say, when I started this paper, I was extremely ambitious because I thought, oh, well, comparative, Singapore, let's look at X, let's look at Y. And then I realized that the Indian landscape was so big that I didn't know enough about the Indian landscape in itself. So I converted this particular piece into a more anthology piece to be able to understand what questions could actually be raised for it to be a relative comparison in the first place. To get go, historically, the Indian listed company landscape has been dominated by a very uniquely Indian concept called a promoter, which is your founder, controlling shareholder who essentially has gotten the company from a legacy perspective. They're defined as a promoter or a promoter group. And the statistics show that family businesses in India account for over 70% of India's GDP, projected to rise between 80 to 85% by 2047. Of the 500 listed companies, apologies, I picked listed companies specifically because the data was more easily available as opposed to private and unlisted entities. And I just wanted to raise the question with listed entities so that we were able to essentially understand the governance landscape with respect to successions in the first place. So the 500 listed companies by market capitalization on one of the stock exchanges, or 2/3 of them trace back to family-founded business. This is a 2013 study. 76% of India's most valuable family firms are currently managed by second-generation family leaders. This is a 2025 report from Barclays and Hurun, and 79% of business plans sort of pass management to family members, with 88% entrepreneurs trusting next generations to manage wealth. This includes a lot of billionaire families that come out of India. So therefore, the questions that I already sort of gave in the background is whether there are limitations in the governance of succession plans and succession events for listed entities in India, and whether there are limitations on the instruments commonly employed to manage shareholding structures in Indian family-owned listed entities, specifically settlement agreements. And here I'll introduce you to this very interesting concept of trust-based shareholding and ownership, which is very unique to India. Now, quickly, the legal framework. The company law in India in 2013 has gone through a large amount of governance and disclosure introductions. I already spoke about this one unique provision of Section 166. There is also a mandate of a nomination and remuneration committee that essentially evaluates director qualifications. The recently proposed amendments also look at director disqualifications and director appointment criteria. Here also independent directors play a huge role in the manner in which they are qualified. But as I will speak to you in the second part, the sanctions on independent directors are so high that they really don't do their job on account of those sanctions, and they rather not do and quit their job as opposed to continue with being the independent director that they are, and we talk about that briefly. Because listed companies have separate regulatory regimes, and one of the questions, again, as I mentioned earlier today, is whether there should be regulation or over-regulation. You do have the listing disclosure regulations in which express provisions have been made with respect to the board of directors of a listed company to satisfy themselves with adequate succession planning. You do have a nomination remuneration committee that works slightly differently with respect to listed companies and reviews succession plans, which are both executive and non-executive in nature. There are material disclosures with respect to succession events that need to be made. And given the market for takeovers right now in India, the acquisition of shares and control in listed companies prescribe thresholds for mandatory open offers, including interstate transfers between this particular community of promoters, which are founders and family owners and relatives within the same family circuit. Then just quickly, why this concept is novel. I've just created a very brief diagram here where you're looking at a promoter group, again, to repeat the definition, to what it would be to mean a promoter group. You effectively have a different branches of the same family who effectively become shareholders of a particular company, right? So that essentially looks at massive controlling stake, and management that segues into a particular family conglomerate that may or may not have any kind of experience in running the management of a company. I'm sure everybody here at some point has heard of the name Ambani, if not about their companies, definitely about their weddings. In the scheme of things, you have two sons and a daughter who effectively own different, in this group conglomerate structure, different businesses, because these are vertical and horizontal businesses in different markets, and they occupy a large market business share from telecommunications to energy to natural resources to retail. You're looking at a large market share owned by them, and these are all run by different family members, right? So in that sphere, you have directors who are from the same family owning different businesses. You have key managerial personnel and senior management from those family businesses. You also have asset overlaps, which has been a very controversial issue recently, because you see the land could be owned by the family, and the building that is built on top of that land is actually the company's. So you also have asset overlaps that effectively demonstrate to a large part how much you have family asset pools, family contracts that effectively govern and shape the manner in which the business is run. And then finally, you have the minority non-promoter shareholders who, while have protections under company law, become subject to the governance and management of the majority promoter group who are from one particular conglomerate. Now, this is not to say, I might be painting a bit of a bleak picture. This is not to say that there has not been good governance practice in family-owned structures, and I will give you a few examples there as well. But because of the market share, and I've already told you about the listed company number, because of the market share that they own, the failures are quite colossal. And in this context, the succession model becomes very important, not just for that individual company, but also for the market at large, because it sets precedent that has a ripple effect within the market ecosystem, which is why the ex-ante measures became relevant, but ex-post enforcement is struggling because, as I mentioned, India is not a high contract enforcement jurisdiction, and in that spirit, it leads to a large amount of considerations with respect to how these succession events come about. Now, I've already briefly mentioned the independent director promoter control model, but I want to talk to you about how governance has been introduced, not just from an independent director perspective, but now from a related party transaction perspective, just to be able to address issues of intergroup, inter-se arrangements between promoter and promoter shareholding structures. Now, coming to some governance case studies. Ex post, what happens when sort of things go wrong? What are the elements of a family settlement? How are the shareholders involved? How do you effectively have a stakeholder alignment, right? So, and there are sort of good case examples and bad case examples. You are looking at, but let's first understand how they work, how they are enforceable. The first one that I want to talk to you about is the Godrej family settlement. This was an unlisted entity, but you needed a promoter reclassification because this particular unlisted company was connected to other Godrej listed entities. So there is an interconnection disclosure that was required, and the value that was involved was very high. Then you have the Ambani family, I already mentioned. This was a very, very big split. I was actually very fortunate that I was interning with the firm that was doing this particular case at that point, and I actually got to research and work while they were representing on this particular case, and looking at that particular governance model of how the arguments played out at the court level was extremely interesting, because you never thought of governance having this much of a ripple impact, especially when two brothers were splitting. From asset classification to understanding what resources could effectively be qualified as assets for the purposes of a private company split was extremely a interesting proposition to have been introduced to at that point. And this was an MOU-based model. This was an MOU-based model. Nobody helped me out with the slides. That's bad. This was an MOU-based model where you did have applicable company and securities law being introduced as part of a memorandum of understanding. And the last one that I want to talk to you about is the Kirloskar Group, where a family settlement allocated group companies between branches with non-compete covenants. Subsequently, litigation that arose was effectively then addressed on a case-to-case basis. Again, large group conglomerate structures really affecting the market, and therefore you're looking at a consideration that needs to be resolved through ex post good family governance, family settlement agreement models, or family run, or through something known as a family constitution, which is essentially another measure that is being introduced from a good governance perspective ex ante. I said I will mention some positive stories, and these are the two big positive stories. And TVS is a very interesting example. Why? Because it's been in the bike business now, the e-bike business, a very large domestic market shareholder, and has been very successfully family run for decades. And they have introduced a lot of management consultants. They've introduced a lot of independent management board structures, which allow the family to still have control, but for them to still implement a successful, profitable, good governance business model. The other one is Murugappa, and here again, a family constitution model has been used. Again, as I said, these are ex ante measures that are being introduced, but whether they are unique to these companies or whether they should be globally implemented is one of the questions that was attempted to be addressed in this particular paper from an India perspective. Now, finally, because Michelle has shown me the time like 4 times now, I want to talk to you about one last thing which is extremely unique to India that implements creates an implementation problem on whether it's ex ante or ex post, and the ownership. Because you see, promoter groups are not just individuals. Okay, I'll take Dan, Michelle, and myself as an example, right? We're all part of the same family, and we're very happy brothers and sisters, and therefore we're running businesses and shareholding very well. Now, assuming that we want to effectively secure the future of our next generation, our children, we constitute a particular trust that is essentially managed, Jennifer, just for example, by Jennifer, right? So there is a percentage shareholding that Dan has through Jennifer, Michelle has through Jennifer, Ishana has through Jennifer, and that also is a shareholding of the same company, right? And then when it comes to a conflict or a dispute, depending on whether it's Dan, Ishana, or Michelle, we can effectively use whatever percentage we have in the trust that is essentially managed by Jennifer to be able to have a larger say in the end result. Extremely problematic, and just doesn't stay in the private space. We have a concept of a Hindu law-governed succession model that also comes into play, where with the structure that I'm sort of mentioning, and they are securities and company law considerations that essentially come into play, and you do have listing regulations that have tried to codify the manner in which succession through what are known as Hindu undivided trusts or private trusts come into play. Now, finally, one of the things that I want to talk about in terms of best practices is next generation. Like I said, a large amount of these succession models or succession events have come into consideration ex post, and ex ante governance measures have been a very slow-moving case-to-case model. Some practices could be charter document inclusions. There isn't enough literature when it comes to unlisted companies and their impact, and unlisted companies are also equally big. Some of them effectively have large amount of market control in sectors which have been subject to anti-competitive issues. But one of the key best practices could be looking at a charter document of succession. You are looking at family constitutions that are a very significant step that are being undertaken by new entities. And last aspect is that of independent external advisors. We've seen it from a TVS perspective, and the separation of roles with respect to promoter and promoter groups. That would be all. Thank you, Michelle.
So thank you. I don't have any slides, but I was very pleased to read this paper. I think you can tell that Ishana and her co-authors are both academics and also practitioners, right? So I think it's a very interesting articulation of the details of family firms in the Indian context. And I was actually quite taken aback. I knew from Umakant's work, Akshaya, Arsha, that of course family firms are very important in India, but I didn't realize until I got to read this paper exactly how prominent they were. Yeah, and so I think that is a very interesting point. Also, things like the undivided Hindu or Hindu undivided family structure, right? Like these, I think, are gems. I don't know if this is different, but it was brand new to me, right, how this works. My comments are obviously not going to focus on Indian law with Umakant, Akshaya, and Arsha in the room. I don't think I add any value to fleshing out the framework that Ishana and her co-authors have done. And I want to compliment them for sort of doing this autopsy of the family firm in India. But my suggestions will be, actually, now that the autopsy is done, I think to have impact, they're in the perfect room here. And why they're in the perfect room is the question I kept on having when I read the paper was, how different is this? And where do the differences actually lie in family firms in India? So to give a few examples that were brought up, independent directors. So a bunch of us in this room did a big project on the independent director in Asia. And what did we find? We found that the independent director was created in the United States in the 1970s to deal with dispersely held companies. Now the US is now dealing with a different problem with their controlling shareholders in SB 21. But it's very interesting because Ishana and her co-authors say, okay, this wasn't working. Why? Because the independent directors are elected by the promoters, the controlling shareholder. That problem, right, is a common problem in putting the mechanism of the independent director into a controlled environment, right? And my question is, how is this playing out differently? I know Umakan, going back to his PhD thesis, wrote on the independent director in this context comparing India and China, right? And so I think for this to be valuable, trying to tease out, right, exactly how different this situation is. I remember from that project, our friends from Seoul National University discovered that independent directors, actually the posts were being filled by ex-government officials, right, who were playing a very different role. And so I think also by putting it to a comparative lens, you can ask the question, maybe they're failing on the monitoring role, but is the monitoring role the only role for our independent directors in family firms? In fact, me and Lulu Lan wrote something on Singapore, and we drew on business school evidence that showed that in Singapore, a longitudinal, very interesting study by the NUS Business School showed that actually independent directors in family firms were playing a mediating role. And so if you're just looking at the monitoring governance role, you don't see it. But that goes into my next point, which is you said there's successes and failures. Obviously, there must be successes because they're occupying, I'll never forget reading the Financial Times when they announced that the capitalization of the of the Indian Stock Exchange was bigger than London. There's obviously been some successes. And the question is, these are family firms, I think, that are driving a lot of this capitalization. And then the question becomes, okay, if we're dealing in a family firm with wealth tunneling, which is a very common story, how do we see this as playing out differently in the Indian context? Are we seeing, is this undivided Hindu structure, is there something unique about? I'm sure there is, but I think you can't see the uniqueness unless you juxtapose it against the chaebol, against family firms in Singapore, against family firms in Indonesia. And I think that's where you have a beautifully descriptive story of India here that's wonderfully researched, wonderfully described, but I think the value will be illuminated when you juxtapose it in this comparative frame. Another example is you brought up RPTs. And there's been a big project, actually, Umakan and I, we did a paper on RPTs in common law Asia. And there's a literature on that. Professor Konchik Kim actually did something in that project on RPTs, repeat RPTs in the Korean sense. So again, I think with the RPT argument, you again have a literature there, right, where you can draw on how is India handling this in the family firm context, right? I do think there's a lot more to be done on this family firm, right? There's been a lot of focus, deservedly, on SOEs in Asia. But these different types of family structures, obviously the controlling minority shareholder in Korea with a chaebol pyramid structure is different than what we're describing here, right? And I think actually the Seoul National scholars have done a great job over the years describing this controlling minority shareholder structure. And people really understand what the chaebol means and this structure because it's been very worked out by the Korean scholars, right? And of course, Umakan and Akshaya, they've done this as well, but it seems you're zeroing in more detail on the family firm. And I think if you could tie it in with what's been done in the past on India, and then try to figure out, well, what hasn't been described, that would be a hugely valuable contribution. And I guess the final point, and I don't like to do this because it seems very self-serving, yeah? But me and Professor Gen Goto, we wrote stuff on, recently we put something out on full convergence, right? And so I think obviously you have an idea here that you seem to have a transplant into India. It looks like you have some sort of convergence on a meta level with independent directors with RPT regulation. But the question is, when you drill down, which is the whole point of your piece, is drilling down, I think you're suggesting that it's working very differently beneath the surface, right? That you have this patina of convergence at the top, but dramatically different aspects in the Indian practice of how this is being played out on the ground, right? And so I think if you could frame that, and we're not the only ones, so I don't want to pretend like Gen and I can say this because Gen is in London dealing with shipping law, that Gen and I are the only ones who've created this term. Jeff Gordon talks about divergence within convergence, okay? So there are a number of people, Uma Khan's work, many people in this room, I think have observed that there is a disconnect between, to draw on another thing, sort of the signal, the halo signal that's been sent out, right? And the reality of what's going on beneath. And I think that you could draw on a number of different pieces of literature to describe, in the Indian sense, why this is maybe another articulation of this sort of faux convergence or divergence within convergence. I think that's what you are actually describing, which is, again, very, very fascinating at the micro level. And I will just end, because I know I have 1 minute left, with a congratulations, which is, I think, every time you do one of these in-depth autopsies that I think in many ways practitioner academics are very well suited to do, like yourself, you uncover things like this Hindu undivided family structure that provide a level of knowledge that I think somebody at sort of a macro level can never get. So I really thank you and your co-authors for that. But I think to have impact, you're going to have to frame it into a larger story. I think you will have impact in India just with your story. But I think if you want to get people to read it beyond India and to contribute to the sort of larger discourse, not me, but people in this room can all sort of help you articulate and identify where the true differences in the Indian story that you've very rightly described lie. And with that, I'm out of time, so I will hand it back to Michelle.